present the Class A records of the Parliamentary Commission of Inquiry into the conduct of the late Justice Lionel Keith Murphy.
These papers open a Pandora's box on the sleazy and murky world of Australian politics 30 and 40 years ago. They've been under lock and key all that period of time. Should they have been released now? The answer is yes.
They should have been kept under lock and key. I mean, they are of no assistance in knowing what's been described repeatedly as the truth about Lionel Murphy.
I wish that this stuff was not out. I wish that none of it had ever happened. I wish that this program wasn't being prepared.
Lionel Murphy isn't here, so does history stop when people die? This is history.
Hello and welcome to Four Corners. Tonight, one of the most controversial chapters in Australian legal, political and media history, the saga of High Court Justice Lionel Murphy. Lionised by some, loathed by others, Murphy's far-reaching reforms as Attorney-General in the Whitlam government helped reshape Australia. But when some of his conversations were captured in an illegal police phone tap operation, Murphy was caught up in sensational corruption allegations that dogged him through the final years of his life. After investigation by 2 Senate committees and 2 court cases, Lionel Murphy faced a final inquiry which could have seen him thrown off the High Court when it was announced that he was dying of cancer. The inquiry was halted and its unfinished investigations were locked away. 30 years on, the inquiry's papers, thousands of pages of them, have been released, prompting some of the key witnesses to the historic events to speak publicly for the first time. As Debbie Whitmont reveals, the passion and controversy of the Lionel Murphy scandal have barely dimmed.
It's an unlikely place for a dark secret. In 1984, a small group of desperate police locked up the cells in this former Sydney police station. Hidden inside, the damning evidence of an infamous 16-year-long investigation.
My absolute understanding is that it was an attempt to reveal corruption, or to, I guess, investigate corruption in New South Wales. And the police that were involved, to my own knowledge, were what people used to call back then the incorruptibles.
This was a world at that time where business was done behind closed doors, where there were no clear divisions between the judiciary and the government and the business of, you know, in those days, an amazing amount of kind of plain old-fashioned corruption in the selling of booze, in prostitution, in gambling. All of that was rife in New South Wales.
The so-called incorruptibles resorted to secret illegal phone tapping because they couldn't trust some of their own senior officers.
You didn't know who was on the right side and who was on the wrong side. They couldn't go to their boss in many cases, particularly certain squads, and say, we want to seek a warrant for so-and-so. The boss would want to know what it's all about. The code of silence is that you shut up. If someone else is doing something, you don't put them in.
Police technicians tapped into phone lines and relayed calls through illegal transmitters.
Well, they would record them, and then back at the office they would have people there who would listen to them and transcribe them. And in many cases they would not always prescribe every word. They would go, and some tapes are better than others. They would, have very good, factual things, or sometimes just summaries.
The illegal phone taps captured thousands of conversations about organised crime, involving lawyers, public servants, politicians and corrupt police.
Those tapes really give you an insight into who was running the place. In a combined sense, they covered a real insight into organised crime as such in Sydney, the power of it and the extended interest.
Sometimes the illegal phone taps picked up much more than the police had been looking for.
They weren't targeting some of the people that finished up on the tape. I think they were shocked when they discovered the voice of their own commissioner.
Police Commissioner Merv Wood would later resign after allegations of corruption. One key phone tap target was a Sydney solicitor called Morgan Ryan.
Yeah, Morgan Ryan was certainly within legal circles and racing circles and just fairly liberal social circles in Sydney, well known to be a lawyer who could get things done, who could get things fixed.
Morgan Ryan's calls showed him at the centre of a powerful network of contacts, from the well-known Sydney crime figure Abe Saffron, dubbed Mr Sin, to the state's Chief Magistrate Murray Farquhar, and a former Attorney General and sitting High Court Judge, Lionel Murphy.
Did you hear the tapes yourself?
I heard one small part of them. I heard Lionel Murphy's voice and I heard Morgan Ryan's voice. I actually knew both of them, not well, but I had met both of them and I certainly knew Morgan Ryan's voice when I heard it.
Frustrated police leaked tapes and transcripts to Bob Bottom.
They felt it should be exposed, so they were not against me using that material to expose some of the realities of what was going on, because they couldn't, for some of this stuff, get other police to take any action.
Those tapes, in one sense, should never have been made. It was against the law to make them. But the fact that they eventually emerged in public, that they emerged through newspapers, meant that the tapes had had no impact behind closed doors. They came out into the open as a last opportunity for doing some good.
The tapes and transcripts came out, first in the National Times and then the Melbourne Age. The story exploded. The New South Wales Premier Neville Wran, a close ally of Murphy's, lashed out at the media.
We've reached the stage where people unknown or people without credit can dump anonymous and admittedly illegal documents on a newspaper's doorstep, and then it becomes the government's task to disprove the anonymous, the illegal, the unproven, and indeed, in most cases, unprovable allegations.
Wran threatened the police who made the phone taps with criminal charges. The incorruptibles panicked. They shredded paperwork, locked the incriminating phone tap equipment in the local police cells, and agreed among themselves to deny that the illegal phone taps had ever happened. They tried to burn the phone tap gear in a backyard barbecue. When that didn't work, they dumped the remains at sea. All that was left were the few leaked cassettes, transcripts and summaries, which fuelled an endless debate about whether the whole illegal phone tap operation had ever really happened.
Is there an original set of tapes, an original set of transcripts that this all material can all be verified against?
Yes, there are original...
How do you know that?
I know, and...
All you say is we must take your word for it.
That's it.
Lionel Murphy argued the tapes were fake. Some of his supporters still do.
view, there's not a scintilla of evidence to authenticate that there were illegal tapes. There's certainly evidence that there were purported transcripts of them, but those transcripts were very difficult to read and were largely nonsensical. And Miss Justice Murphy denied explicitly that the Murphy that was referred to in them on many occasions was he.
What did he say to you about that?
He thought that they were fabrications.
I think there was only one conversation in existence where we actually had a tape of Murphy's voice. So all the rest depended on transcripts. The transcripts had been done by the police conducting the taps. They were full of errors, full of obvious mistakes, totally unreliable.
There were 500 pages of transcripts in the so-called age materials. Lionel Murphy's name appeared on 5 of them. There was, without doubt, he became the lightning rod for the discussion of those materials, and you might consider it a way of avoiding other persons named I don't know.
Lionel Murphy was a figure of enormous controversy. He was a visionary Attorney-General, aggressive, a passionate reformer. He was detested by Conservatives. And of course, in terms of his personal life, Lionel was a charming man, flamboyant, great company. He worked hard, he played hard. There was always a degree of question about his private life, but that was just part of Lionel.
A decade earlier, Lionel Murphy had been a central figure in the Whitlam government and in some of its worst scandals. Signing off on the loans affair, an attempt to borrow billions of dollars from a shadowy businessman, and leading a bungled raid on ASIO headquarters. But as Attorney-General, Lionel Murphy also led many of Whitlam's most significant reforms.
I've got an emphasis on matters of democracy and ensuring personal freedom. I think the party needs to concentrate far more on these matters than it's done in the past. I think in the future that we ought to concentrate much more on the questions of personal freedom, democratic procedures and dignity of the individual.
It was Lionel Murphy who introduced the Family Law Act and no-fault divorce.
Murphy leaves a legacy of law reform and rights, human rights, and the protection of individual freedoms that is unsurpassed in our legal history, in our political history. And I think the great shame to me is that we give the enormous coverage to what constituted 3 years of his life of relentless claim, not prosecution, persecution.
There was the Trade Practices Act, there was the Freedom of Information legislation, there was the Companies and Securities legislation, there was the Racial Discrimination Act, hugely important. There was the establishment of the Law Reform Commission, there was the establishment of the Criminology Institute. Everywhere you look, there's a legacy of incredibly positive achievement on his role as Attorney-General.
Lionel Murphy's appointment to the High Court by Gough Whitlam was contentious.
There was this immense animus against the whole of the Whitlam government, and on top of that there was additional animus against Lionel Murphy because he was irreverent, he was unorthodox. People either loved him or hated him. And maybe both reactions were exaggerated.
Mr Justice Murphy of the High Court was named in the Queensland Parliament yesterday as having been mentioned in the secret police tapes.
In Canberra, the phone tap allegations were the last thing the recently elected Hawke government wanted to hear.
I think the position of the Hawke government was, initially, they didn't want to know about this, they didn't want an inquiry, they wanted it to go away.
When you had material that was not only unauthenticated, but if authentic, was clearly obtained in circumstances of great illegality, when you had material which grossly outraged personal privacy, when you had, moreover, material that amounted to a head-on assault on the judiciary, there's an obligation on the press to stop and think, to weigh and balance those considerations and say, is there a way this interest can be served than by splashing it all around the world in the way that they did?
I was disbelieving that it could possibly be probative of anything resembling criminality on Murphy's part, because fast and loose though Murphy might be in all sorts of ways, unwise in some of his associations. I mean, he was a guy who was passionate about the law and the principles of law, and I couldn't really believe it.
But Labor didn't control the Senate, and it set up a committee which almost immediately let loose a new chain of stunning allegations. The man at the centre was New South Wales Chief Magistrate Clary Breeze.
Yes, just stand up, Mr. I will take into account the matters which you'll put to me through your solicitor.
This story happens because a new kind of man was appointed New South Wales Chief Stipendiary Magistrate, Clary Breeze, who is the real hero of all of this. Not the press, not the brave politicians who stood up to the pressure to keep quiet. Clary Breeze is the hero here.
I certainly believe it was proper for me to have done what I did. I had to come forward to expose the corruption which was then operating in the magistracy and the judiciary in those years.
This is the first time Clary Breeze has told his version of the story publicly in 30 years.
Can you set the scene and tell me how it all began?
Yes, Murray was to retire in May. That's Murray Farquhar, the chairman.
Back in 1979, Clary Breeze was applying for the job of Chief Magistrate to take over from the retiring Chief Murray Farquhar, who was later jailed for corruption. Farquhar questioned Breeze about doing favours for the Premier, Neville Wran.
He asked me what I was like on favours, and I said to him, well, what sort of favours are you talking about? And he said, oh, little things like PCAs. He said, would you handle things like that sensitively for the Premier?
Prescribed content of alcohol, drunk driving cases.
That's that kind of thing, yes.
For the Premier?
For the Premier, yes. Well, I wasn't certain what he actually meant by this, and so I simply said to him, well, I'll just handle them as sensitively as I could, and left it at that. But he then, without hesitation, said, well, you've got the job.
What Farquhar said next took Breeze by surprise.
He said to me, he said, you've got the job. He said, and I'll introduce you to the Premier's chief advisors. And I said, who are they? He said, Morgan Ryan and Lionel Murphy. Well, that surprised me. I knew that Lionel Murphy was a High Court judge.
Shortly after that, Farquhar invited Breeze to what he called a party at the waterfront home of the controversial solicitor, Morgan Ryan.
He made a special point of saying that the Commissioner of Police will be there. So I assumed that there would be other people there as well when he said it was a farewell party to himself. And when I got there with him, there were only the five of us.
Apart from Breeze, Farquhar and Ryan, the only other guests were Lionel Murphy and the New South Wales Police Commissioner, Merv Wood. Afterwards, Murray Farquhar was keen to keep that guest list a secret.
But he said, don't tell anybody about the dinner because they might get the wrong impressions. He said, I've done nothing wrong.
As Chief, Clary Breeze wanted to reform the magistracy. He enlisted Murphy's support. Over the next few years, the two met on several occasions. Then one day, Murphy phoned Breeze. They both knew that Morgan Ryan had been charged with conspiracy and forgery over an illegal immigration racket.
He said he had a matter he wanted to talk with me, but he didn't want to do it over the phone. I suggested, well, do you want to meet in the street or in a restaurant somewhere? And he said, no, that wouldn't be satisfactory.
Breeze invited Murphy and his wife to dinner. There was discussion about a long-running conspiracy case. Then, according to Breeze, Lionel Murphy raised the case of his friend, Morgan Ryan.
And he said, well, I'll tell you about another wrong case of conspiracy, and that's the Morgan Ryan case. Well, that was just the thing I didn't want to hear. And I said, well, what's wrong with it? I think he said he's read the evidence, that it was weak, didn't support a charge of conspiracy, and he was concerned about it.
Breeze says he later told Murphy the Ryan case looked like going ahead.
And Lionel said, the little fellow will be shattered.
What did you think when he said the little fellow will be shattered?
Well, obviously I knew that he was concerned for what was going to happen to Morgan, and he wanted something done about it.
Soon after that, Breeze says Murphy phoned and told him the reforms he wanted had been agreed on. But according to Breeze, that wasn't all Murphy said.
I replied by saying, well, that's good news, I'm really glad to hear that. He then said to me, and now what about my little mate? Just like that.
Those words would become the focus of enormous controversy. Breeze's account, which he later gave to a Senate committee, was flatly denied by Lionel Murphy, including that he used the words, "What about my little mate?"
Murphy totally denied that part of it and said that or even though he was a member of the Labor Party, he never used the word mate. It just wasn't his language. He never would, not only did he not say it, but he never would have said anything like that.
Do you find that plausible?
Yes, I do.
I can honestly say, in all the many hours and many days extending over years that I spent with Murphy, I never once heard him use the term mate. Just never heard him use the term mate.
But Clary Breeze's statement soon flushed out more allegations. Jim McClelland, now deceased, was then Chief Judge of the Land and Environment Court, and like Murphy, a former minister in the Whitlam government. McClelland asked Wendy Bacon to meet him.
And I remember his first words were, after we said hello, his first words were, "I want you to know you're on the right track. You should just keep going with all of this." And then he said to me, I know, because I know myself, that Lionel Murphy tried to get me to influence the Morgan Ryan case. So we both knew what the Morgan Ryan case and what he'd been charged with.
Jim, he always said he loved Lionel. He did. I mean, Jim was very, very affectionate person. He was very affectionate with his friends, and he really adored Lionel. I think admired him enormously for his intellectual capacity.
Jim McClelland's widow, Gil Appleton, remembers McClelland getting a phone call from Murphy.
I could tell he was being very testy with Lionel, and when he got off the phone I said, "What was that all about?" And he said, he wants me to get an expedited hearing for Morgan Ryan. And I wasn't really attuned to legal talk, and I said, what on earth does that mean? And he said, well, it doesn't mean what it sounds like. He said, what he means is he wants me to lean on the judge that's going to be sitting on that particular case. And the judge was someone that Jim knew.
Rosemary Flannery's husband was District Court Judge Paul Flannery.
There were a number of people who knew a lot of things that were going on in the law,
in the magistracy, in the police force, in politics, and who were frightened to speak up. When Paul read what Clary was saying to the Senate inquiry, he realised that Lionel's modus operandi was the same for Clary as it was for him. And he thought, you know, there's something going on here. And he thought, I've got to, you know, speak up.
Paul Flannery was the judge assigned to sit on Morgan Ryan's trial. Flannery said, though Lionel Murphy denied it, that Murphy asked Flannery to call him.
I guess being a High Court judge, Paul being a District Court judge, which is down the scale a bit, Paul felt that he had to ring, and he did, and Lionel said, could we come to dinner on the Saturday night, the 9th of July, at his apartment in Darling Point. And Paul accepted that invitation. We drove out to Darling Point. He had a view of the harbour and he was showing us around the view. And then we had dinner.
The dinner was just 2 days before Morgan Ryan's trial. Lionel Murphy referred to a particular High Court conspiracy case. Morgan Ryan's name wasn't mentioned.
Then, you know, we said our farewells and we went down to the car. I was driving and Paul said to me, just sit for a minute. And we just sat before I turned the motor on and he said, I think he's trying to nobble me. And we drove home.
When Paul Flannery died a few years ago, his wife Rosemary came across his judge's bench book.
All the pages of it were stapled up with old bits of paper, coloured paper. So I tore off lots of these bits of paper and I started reading some of the things that Paul had written when he was trying to make up his mind whether he would speak out on the Murphy charges. I had this moral dilemma whether to speak up on one hand and the implications of speaking up for Murphy and me and my family against the principle of truth, how I could sit by and be a judge.
For the first time in Australian history, a High Court judge today appeared in court on criminal charges. Mr. Justice Murphy is facing charges of attempting to pervert the course of justice.
Lionel Keith Murphy arrived at Sydney's Castle Ray Street Court this morning.
In late 1984, Lionel Murphy was sensationally charged with 2 counts of attempting to pervert the course of justice in Morgan Ryan's case. Never before or since had a High Court judge faced criminal charges.
Look, it was electric. It was in the papers and on the television screens every day. I have the most vivid memories of walking around the streets of Sydney with Murphy, and complete strangers would come up and wish him well. Derelicts would wish him well. And all sorts of people wished him well in the court and outside the court.
The legal community was divided over the strength of the charges.
One was flimsy in the extreme. It depended upon Murphy meeting Flannery at a legal convention, and it depended upon Murphy inviting Flannery to dinner. The Breeze case depended upon, largely, the allegation of, now, what about my little mate?
I don't think that any of the allegations brought forward by Flannery or by Breeze could be described as flimsy. These were 2 very senior lawyers occupying positions of authority and prestige in the community. The whole context of the connections, the meetings, the dinners and all the rest of it, against the background of what was happening in court, brings meaning to the whole encounter. Murphy, for all his faults, was a very intelligent man, an experienced politician, somebody who understood what communications were about, and somebody, I think, who could communicate his own wishes and intentions without being too direct about it.
Of course, Murphy's nowhere on the record saying, "I want you to nobble Morgan Ryan's case." Of course he's not. But, you know, a couple of judges, a chief stipendiary magistrate knew what his language meant and that was his intention.
The trial ran for a month.
I remember the return of the verdict in the first trial very clearly, because it was an extraordinarily tense occasion. You could have cut the air with a knife.
The jury found Murphy guilty, on one charge only, of attempting to influence Clary Breeze. Lionel Murphy potentially faced prison.
Last night, the judge was convicted in the New South Wales Supreme Court of attempting to pervert the course of justice. The jury found him not guilty on the other similar charge he was facing.
Members of the jury were clearly upset and showed outside the court signs of the tension of their marathon deliberation. Today, the verdict was front-page news across the country.
Anguished jurors, including the foreman, took the unprecedented step of speaking out publicly.
I don't think anybody who's commented has any idea of the month out of our lives, the anguish, the heartache and the misery we went through to do what was required of us. For what it's worth, we all agree we were looking at a good man who answered a call for help.
Murphy and his legal team appealed and won a new trial. This time, the defence adopted a controversial strategy.
I knew that Murphy loved Christmas. I thought, I know what I'm going to say to him. I'm going to say to him, you better realise that you're going to be in prison next Christmas unless you take our advice.
That advice was to make an unsworn statement to the jury, known as a doc statement.
What it did was mean that he could not be cross-examined on all of the evidence that had been accumulated about the world he was the world he was swimming in, the things he had done, the people who were his friends. He kept all of that evidence out of court. It was a humiliating thing for a High Court judge to do.
I was stunned. I thought, how can you possibly think that a High Court justice would take that course? Of course, it was legally open to him to do that, to make a doc statement. But this was a provision that was put in place for people who were uneducated, people who had difficulty with the language, people who had disabilities of one kind or another which made their understanding imperfect.
What he was doing was exercising the same right any other person would have had in the same circumstances. Firstly, he was taking the advice of his lawyers. Secondly, it was the only sensible way to conduct his defence. I mean, the doc statement wasn't something Murphy invented.
Look, this is just as if it happened yesterday. Barker called on him to address the jury, and he stood up, and he was always slightly dishevelled, and he sort of straightened his tie and straightened his coat.
He did it very well, I must say. He walked to my left and right around the bar table, almost got in the jury box, and gave his statement. I think what annoys a lot of people is that he gave it very calmly.
Murphy flatly denied trying to influence Morgan Ryan's trial and said he never used the words, "What about my little mate?" His categorical denial convinced the jury. Murphy was acquitted.
Mr. Murphy, how do you feel?
This has been a political trial, and I hope there are not going to be more political and show trials like this. The first trial, I gave evidence, and I was subjected to a political attack breaking through my career in politics. I was determined that this would not occur on this occasion. Thank heavens for the jury system. It's the protector. Yes.
How did you feel after that verdict? Were you comfortable with it?
You see, when the jury finds that a person is not guilty, they're not. It's not a finding that the person was innocent. It's a finding that on the evidence they heard, it wasn't sufficient to satisfy them beyond reasonable doubt that he'd committed the offence. It's not a finding of innocence.
Murphy had won a battle, but he wouldn't win the war.
The High Court was profoundly concerned. At the end of the day, they got alarmed about the Murphy case. I think there was a sense of panic on the court, that the court's standing and reputation would be damaged. The court was particularly concerned about the risks of Murphy continuing to sit on the court, and they made this clear to the government.
A significant number of them had a problem sitting with Murphy, and therefore the government, faced with that, had no choice but to once again pick up the pieces and try to find a process which would resolve the issue once and for all.
Murphy refused to stand down from the High Court.
This was uncharted territory. Murphy kept taking both government and the judiciary into this uncharted territory. Murphy was so tough, so hard-boiled, so determined to hang on, that he dragged the process into that territory where these kinds of decisions had to be made for the first time.
Forced to act, the government set up a commission of inquiry into whether there were grounds to remove Murphy from the court.
The Parliamentary Commission will be the 6th formal investigation into Mr Justice Murphy's conduct as a result of the Age tapes.
It was a very unusual brief because ordinarily one receives a brief in which the facts are set out and usually the contemplated charges are set out. This one said it's up to you and your juniors and those working with you to find out the facts and determine whether there is any material that could be put before a parliamentary commission.
The inquiry's main starting points were the illegal police phone taps.
We were given the transcripts of various tapes that had been illegally taken by the New South Wales Police and which had ended up in both the National Times and the Age with lurid headlines. We started with those and we then made a round of various people who might be able to give us information. Most were not very enthusiastic to speak to us.
And the inquiry put an ad in the paper calling for public submissions about Lionel Murphy.
We got responses to it from a variety of different areas. We got a lot of crazy material given to us. Some of them, nonsense like he'd been a Soviet spy and matters of that kind, we disregarded without even investigating it. But we investigated to the extent that we could.
The Commission reduced the allegations to a list of 14. None were ever tested. 2 involved allegations of attempted bribes. Another 2 turned on whether Murphy had tried to do favours for a well-known crime figure, Abe Saffron.
Was there any direct evidence of any links between the judge and Abe Saffron directly?
I think the answer to that is yes.
And were they substantial or potentially damning?
I'm speaking from long recollection, but my recollection is that the judge had not attempted to hide his association with Saffron.
A very old association?
A long association, yes, yes.
And was that a problem? Do you think that could have amounted to
look, a mere friendship with someone like that would not of itself be a ground for amoval. No, there had to be more than that.
The allegations that Lionel Murphy intervened to help Saffron win lucrative government contracts have never been proven.
If, for example, you've been able to show that beyond reasonable doubt, would that, do you believe, have been sufficient?
That is, again, that's not a question of illegality, but it is a question of entering into matters which I think most people, most senior judges would say is not what a High Court judge should be doing.
I think it is time to draw a line under it. I do, despite what some people might think, believe in the presumption of innocence. I'm very happy for people to be presumed to be innocent of wrongdoing unless and until there is evidence that shows otherwise.
The inquiry lasted only 3 months.
It was only just getting started when Murphy announced that he was dying of incurable cancer and had 3 months to live. The moment he said he was dying, it was all shut down.
For 30 years, the inquiry's papers were kept locked away. Even now, with their release, the polarised emotions around Lionel Murphy and the unresolved allegations have barely dimmed.
They're an enormous jumble where you have to, all sorts of bits and pieces of scribbled pencil notes and transcripts and copies of Penthouse magazine, all sorts of stuff just jumbled up together.
I think it's beholden on all of us to treat them extremely cautiously and to acknowledge first and foremost that they have not been tested. They have not had an opportunity to be corroborated, much less challenged by Lionel Murphy himself or his lawyers.
A number of them would have been thrown out, and because we couldn't prove them or witnesses were not adequately believed. I think on some of them we would have made them good. It would still have been a matter for Parliament to say whether Parliament was satisfied that the judge should be removed. And absent a serious conviction of a criminal type, I think it's most unlikely that Parliament would have found that.
The trouble is, you've got to take each one of these individual things on their own, and 0 plus 0 plus 0 plus 0 still adds up to 0. And everything else is just gossip, everything else is just innuendo.
Lionel Murphy's last High Court judgments were handed down in October 1986 on the day he died. His memorial service was overcrowded with mourners from all walks of life, all 6 High Court judges and former New South Wales Premier Neville Wran.
There used to be a good Australian word for the value of openness and equality in our society. I'm proud I can still use that word for Lionel Murphy. He was my mate.
A few months after Murphy died, the conspiracy charge against his friend Morgan Ryan was dropped. It will never be known why Lionel Murphy would have risked so much.
Lionel played fast and loose. He always cut corners. He loved the exercise of power. He thrived on the exercise of power. But the exercise of power always involves unsavoury activity to a certain extent or other. And what we saw in the case of Lionel Murphy is all the sense of pent-up worry and aggravation at that time about crime and corruption eventually became focused on the figure of Lionel Murphy, because he sat at the apex of the Australian system of government, at the apex of the Australian Constitution. He sat on the High Court.
Lionel's gone, but history continues to puzzle over what happened then, to work out what it meant for the politics then, and of course what it means for politics now. And it has a very powerful lesson for politics now. Because what you see through the lens of the Lionel Murphy case is how politics was played before we invented ICACs, before we invented standing commissions whose task is to seek out corruption. This was corruption. And this is a reminder, 30 years down the track, of why we need corruption commissions and why we need them to be powerful. That's the weight of the Murphy story now.
The Murphy story indeed shows why history matters. That was our final story for the year. We're taking a break, but work is well underway on some cracking investigations that we'll be bringing you in the new year. If you'd like to watch any of our groundbreaking programmes from this year, you can find them on our website. Next Monday at 8:30, Foreign Correspondent begins its new season with stories from around the globe. Don't miss it. See you in the new year.